Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina, and today's topic, what's the fix? Understanding monopolization claims and remedies in cases involving platforms. Digital platforms are under immense public scrutiny, both here in the United States and abroad. Most practitioners will probably tell you it's not a matter of if, but of when some of the largest platforms will face monopolization claims by public agencies and private parties alike. Indeed, even Congress has made calls for some action. On October 6, 2020, the House Judiciary Committee released a report summarizing its findings from a years-long competitive review into some of the biggest platforms, including Facebook, Google, Amazon, and Apple. Much has been said about the competitive harm that these platforms can cause, and I fully anticipate the issue will be a hotly contested and litigated one. But there has been significantly less attention paid to how best to formulate a fair and robust remedy. We discuss both in this episode of Our Curious Amalgam. Joining me today is my co-host, Anora Wang. Hi, Anora.
Hi, Christina.
So, platforms. Why are we talking about platforms today?
Well, as you said, antitrust scrutiny of digital platforms is hot. We want to understand how, giving the House report, which comes as a complete and drastic overhaul, or calling for overhaul of the U.S. antitrust law. And then we want to understand how this wave of actions should be understood under the U.S. antitrust law. And then if we do analyze it as an antitrust problem, what's the complexity and difficulties in assessing the power and markets involved in digital platforms. And then what we really want to do, as you said, is try to beat the crowd and think ahead. What kind of remedies would be desired and feasible? So in short, what's the fix?
Definitely a lot being said on this topic right now. Who's our guest today?
Our guest, Professor Herbert Hovenkamp, is really someone who doesn't need introduction in the world of antitrust. As a fellow of the American Academy of Arts and Science and a winner of the U.S. Justice Department's John Sherman Award for his lifetime contribution to antitrust law, Professor Hovenkamp is a scholar and author I trust that all antitrusters should have read. Will read and will continue reading. So his scholarship, including the very famous Rita Hovenkamp series, which I assume occupies prime real estate in many practitioners' offices and now home offices. And also now we're going to talk a little bit more about his recent work, which focusing on exactly what we're going to discuss today, which is the remedies involved in digital platform monopoly cases.
Great. Well, without further ado, Professor Herbert Hovenkamp, welcome to the program. It's great to have you.
Well, thank you very much. I'm very pleased to be here. This is my first time, so I'm looking forward to it.
We're very glad that you joining us. And then I'm speaking on behalf of myself and many who once were law students reading your scholarship. So just without further ado, setting table is done. We want to go to the core complexities or difficulties in assessing monopoly power, I guess, involved in digital platforms. What are they in your view?
Well, first of all is how to measure it. Traditionally, we measure market power by defining a relevant market and computing a share. That poses some very serious problems among the platforms. First of all, the markets are product differentiated, which means the individual offerings don't compete head-to-head, and market definition methods, they're basically always wrong when you're talking about differentiated markets. If you group two things together, like internet advertising and traditional advertising, then you end up treating them as perfect competitors, which we know isn't true. On the other hand, if you define the relevant market to include only internet advertising, then you end up suggesting that traditional advertising doesn't compete at all, which is also inaccurate. So problems with market definition are pervasive among among the platforms. The other problem for market definition is identifying exactly what products a platform operates in. Amazon operates in a lot of products, some of which, like ebooks, it has a very significant market share, and others like tires, in which its market share is negligible. In the last 15 or 20 years, economists have gotten a whole lot better at measuring market power directly, mainly by looking at quantity changes in response to price changes. Those methods can be much, much more accurate. Technically, they do not require a market definition. Their one limitation is that you need to have adequate data in order to use them, but with respect to the platforms, all of the relevant transactions are digital, so it's pretty easy to come up with the adequate data. So I think as we move more and more into the future, we're going to see more and more direct measurement using econometric tools than traditional method. The downside, of course, is that it does require an expert. This is totally an area dominated today by economists, and we'll see more of that in the future.
Right. So you talked about the use of direct evidence, just so that our listeners would know that's in contrast with market share, which would be an indirect measure, right, in the contrast. And then do you think, coming back to the House report that we have already pointed to, do you think they have overall the right approach in assessing the market power in their studies or investigations? Have they used direct evidence more compared to traditional investigations?
They appear to be using indirect evidence more. They talk a lot about market shares of sales, and things like that, and they really don't speak all that much about things like demand responses to changes in price. Now, those are really litigation questions. The report simply asserts that platforms have a lot of market power, but that, of course, is a question that's going to have to be established once we get into court.
And I think it'll be an interesting challenge, just given the historical landscape or framework in which courts understand these cases, which is the traditional market share, concentration levels, and this concept of market power using effects analysis is something that's happening in practice, but less so in the courts.
I think it's going to be one of the biggest education overhauls, particularly for the judiciary, for the federal courts, over the next generation or so, because way too many people have been taught to think of market share in a properly defined relevant market as the way to measure market power, and getting away from that is not going to be very easy.
Yeah. And I think your paper, which we will put a link in our episode page, is that you think the court's acceptance to the use of direct evidence is spotty, right? In at least certain types of antitrust cases. Do you think that's something that ought to be changed, and in particular in certain types of antitrust cases?
Well, the Supreme Court has never been very sophisticated in its approach to this. It has permitted direct evidence in a couple of cases, and I think correctly. In the activist case, it noted that the ability to make a high payment for delay is a sign of market power. A perfect competitor would find it worthless to pay another competitor to leave the market. We really don't have a database of case law that works up the appropriate uses and limitations of direct evidence. Now, the lower courts have done a little bit better, and the enforcement agencies have done very much better in one area in particular, and that's so-called unilateral effects theories of mergers, where the predominant mode of analysis is to look at power of merging pairs of firms. And for the most part, the technical measurement in those cases does not require a market definition. And for the most part, and I want to hedge this a little bit, for the most part, the courts have let them go ahead and do it. But that's, I think, where we're going to see more direct evidence coming in the door.
Right, right. And then coming back to, I guess, another area that's really hotly, closely watched, which is Section 7 Clayton Act enforcement under that in the platform context. And then do you think it's particularly causing concern when we're talking about platforms and relying on market share as traditionally required in cases that's litigated?
So we're talking about mergers, is that correct?
Yes.
Yeah,
Mergers and
I think mergers are a big problem. I'll just preface it this way. I do not believe that the big platforms are inherently winner-take-all markets or natural monopolies. A natural monopoly can exclude everybody just by setting a competitive price, because once it gets to 50+% of a market, nobody else will have the same cost advantages that it has. The dominant platforms need exclusionary practices in order to maintain their positions because there is competitive turnover. There's a lot of technology change, a lot of enhancements, and so on. And the one vehicle that has proven to be most successful for the big platforms is to acquire very small startups before they get very far along. I mean, the one thing you need to remember is every one of the four firms we're talking about, including some others like Intel and Microsoft, every one of these firms started out in someone's garage. These were tiny, tiny firms. Bill Gates, when he got his very first contract with IBM, everybody knows the Facebook story because it involved a couple of kids at Harvard, Apple with the Trash 80 and Stephen Jobs and Wozniak and so on. You can just go down the list. These were tiny firms run by people with very good ideas, and they grew into the powerhouses that they are now. And the managers of the platforms know that. And so they basically gobble up small firms with good ideas frequently before they even have a market share, because although they have a good idea, they haven't actually made their first sale yet. Or when they have made sales, they have market shares down in the 0 to 2% range. And one of the problems is that current merger law, as it's enforced, doesn't permit going after mergers on such small market shares, and particularly not if they're not mergers of competitors. A lot of the acquired firms are not literally competitors of the acquired firm. They're really, they'd be better described as complements. And current merger law is simply woefully inadequate in dealing with these small acquisitions, but I think they are a significant explaining force in why we are not seeing the more robust emergence of new platforms.
I'm glad, and I think that's a very, very insightful point. I'm glad you brought about a common held view that, platforms can be viewed as sort of like utility, almost a natural monopoly type of entity. Some claim it, nowadays everybody uses platforms so often, and so it's so commonplace that it becomes almost utility or essential facility. That kind of argument, especially it's acute, I think, in Section 2 cases. What do you think? Do you think that's a good analogy? Apparently not, right? That's not natural monopoly in your paper that you have explained. But how do you deal with this argument when it gets to the Section 2 space?
Are we talking? You mean about refusals to deal?
Yes.
I'm a little leery of going too far to the left on refusals to deal, because I think they do run into the problem that they can deaden entrepreneurial initiative if they just give firms kind of a right to hook into something else. On the other hand, I think systematic refusals to deal by dominant firms when there is no good likelihood of competitive entry can be and should be identified as anti-competitive. For example, I totally agree with Judge Koh's opinion in the Qualcomm case that Qualcomm's selective refusals to license to its competitors, now that violated a FRAND obligation, which is a contract. Judge Koh held that it also violated an antitrust obligation, and I think she was precisely right on that. Unfortunately, the Ninth Circuit didn't see it that way.
So if we assume an antitrust case on platform is inevitable, and then we do need to think about remedies and think that's a good segue to the next bucket that we want to cover, what kind of goal would we want to achieve in such a remedy, and what kind of thinking should go into the design of the remedies?
Well, as a first premise, I think the goal of a remedy ought to be the same as the underlying goal of the antitrust laws generally. And that has not always been the case. There's kind of a disconnect between statements about what the goals of the antitrust laws are and about what the ideal remedy should look like. I happen to believe that the goal of the antitrust laws should be maximum output in a market consistent with sustainable competition. That's actually the consumer welfare principle, except stated with output rather than price as the important variable. High output benefits consumers, first of all. They get lower prices and more availability. High output benefits labor. There's no antinomy between the rights of labor and those of consumers if you measure consumer welfare in terms of output, because greater output creates greater entrepreneurial opportunities, and as a result, it creates more employment opportunities. And then, all things being equal, higher output also creates more opportunities for collateral businesses, suppliers, and others who deal with the big platforms. Now, how does that relate to remedies? Well, I think the one thing we need to search for is remedies that don't address the problem by simply trying to hobble the big platforms in ways that reduce output or cause consumer harm. I think cutting off products, telling Amazon you can sell third-party products on your platform, but not products of independent merchants. That's not going to make anybody better off. It's going to increase prices. One of the reasons, the ability of Amazon to put something like Amazon Basics alkaline batteries, household batteries, like the kind you use in your smoke alarm or flashlight, the ability to put those batteries on the website opposite batteries from companies like Duracell, right? Duracell is owned by Berkshire Hathaway, not a little firm, okay? The result is that customers get a choice between the house brand and the name brand, and they get the benefit of lower prices. Now, if we force Amazon to take its Amazon Basics batteries and put them on a different website, or worse yet, not to sell them at all, consumers are going to lose the benefit of that competition. By the same token, I don't think we should be going through the platforms and knocking off lines of business, telling Facebook, okay, this service you may no longer offer. The thing that makes the platforms attractive is because they are multi-product or multi-service. You can get a lot of different things. I mean, you think of how you use Facebook, right? You can post messages, you can have bulletin boards, you can post photos, you can post videos, you can do a whole lot of different things. And slicing off one of those things is not going to make consumers any better off. So I think we need to look at non-structural remedies, and there's a whole group of alternatives. One of them is injunctions. Mm-hmm. The easiest and simplest and frequently the most direct solution for an anti-competitive problem is an injunction. For example, Google has been accused, I believe correctly, of favoring Google search on various devices and technologies. For example, Google search is the default engine on Android phones. Google pays a lot of money to Apple in order to be the default search engine on Apple phones. Well, we don't need a restructuring remedy to solve that problem. For the payment, we need an injunction. We should enjoin Google from paying Apple so that Apple makes Google the default search engine. The other thing we can do is what the EU is currently doing with Android phones, which is you add one additional startup screen to the set of menus you get when you buy your new Android phone, right? You buy your new Android phone, you turn it on, going to ask you a bunch of questions about your demographics, where you live, what language you prefer, and so on. And one of those startup screens can simply ask, what would you prefer your default search engine to be? In fact, if you look on the EU's Android website, you see some samples of screens like that. So
right.
Google search or DuckDuckGo or Yahoo or Bing, and you select your own default search engine, and that puts that choice in the hands of the customer rather than in Google's hands.
Right. Let's come back a little bit to the broad distinction between structural remedies and behavioral remedies. And I think in your paper you said divestiture, I quote, is a blunt instrument. And I think in dealing with the monopolization, monopoly concerns with platforms, you're exactly right. Injunctions can be more precise, can go straight to the practice. But I guess you do hedged a little bit, saying that the case for breakup is the strongest, or if there's one, is when the non-competitive performance or conduct seems to be inherent. Do you see anything that's inherent in at least surfaced from the House report or from whatever observations or studies that you have reviewed?
I see some things as inherent, but I think there are better alternatives than a breakup. But before I get to that, let me just add one thing. Mm-hmm. I'm not opposed to every single breakup. I think there's a strong case to be made for breakups in merger law when we're talking about relatively recently acquired assets. The government has the authority to, first of all, to enjoin a merger prospectively, right, which is what it does most of the time. It also has the power to go after consummated mergers and get injunctions of recently acquired assets. The history of breakup remedies in Section 2 cases is not very pretty, with one outstanding exception, and that's AT&T. Mm-hmm. But the breakup of Standard Oil immediately produced higher gasoline prices. The breakup of United Shoe Machinery was a major contributor to driving that firm into bankruptcy. The AT&T consent decree was a breakup that worked. It was also a pretty exceptional one, however, because that consent decree did two things at the same time. One is it broke up AT&T, but also it eased the transition of AT&T from a top to bottom price regulated utility, which is what it had been. Everything, local service, long lines, that was AT&T's old long distance subsidiary, and Western Electric, its subsidiary for instruments, was all treated as a singular monopoly. AT&T was very aggressive about protecting its right to exclude everybody in that. And so, that was a rather exceptional antitrust remedy. With the platforms, we don't have any of that. We've got firms that started out as competitive. We would still like to see them as operating in a competitive environment. And there are not very many breakups that would make consumers better off.
Right.
As far as I can see.
I think that's a really interesting and important distinction to make. There are obviously recent discussions around why structural remedies are preferred in the merger context, as you mentioned. But in a monopolization case where the entities are, as we say, already scrambled, what are the precise remedies that can be made? Although there are people do not like behavioral remedies because it involves court interference with the markets for some period of time. And there are a lot of questions as to the enforceability of those agreements and those injunctions. But perhaps the better instrument in the context of a monopolization claim.
I think the first place to look beyond injunctions, that is to say, once we've decided a simple injunction against a practice is inadequate, one of the places we should look, and this particularly applies to Google and Facebook, is information sharing, sometimes called interconnectivity. But basically, the reason the platforms have an edge in so many technologies is because they have very large databases of information. They have an improved ability based on an economy of scale, which is global, an economy of scale to identify who users are, what their preferences are, what their geographic and other demographics are. And as a result, they have significant advantages. And to the extent that information can be shared, and I think the report is quite good on this particular subject. To the extent that information can be shared, it would tend to level the playing field. And secondly, it would tend to increase rather than decrease the range of positive network externalities that come out of networks, right? Networks work most efficiently. They're two-sided platforms. They work most efficiently when they get very large groups of users on one side and very large groups of suppliers on the other side. Well, information sharing actually aggregates the information. So as the information database becomes bigger, performance becomes better. It happens voluntarily in markets in some cases. The best example I can give you is Insurance Services Office, which you may not have heard of. Insurance Services Office is a firm that shares statistical loss data for casualty insurers, automobile accidents, for example. One of the things we know about statistics is, like the big informational databases, the quality of a statistical database improves as the number of hits gets bigger. And so small insurers send their data to Insurance Services Office. Insurance Services Office aggregates them and then produces this very large, very high quality database, and everybody can subscribe to that. And then they can focus on other kinds of features in determining how to set price. We could do the same thing with Google Search, for example, and with some other technologies.
I think that's exactly right. And I think the report does cover this, as you said. Well, I think I need to, I would be remiss if I do not mention the other hopeful for remedies that you think might work, which is the internal decision-making structure, if there's any change that can be made. I think briefly, if we can go to that, and then can we talk about that?
Yes. Under the Copperwell Doctrine, we almost always treat corporations and business firms as single entities. However, there are an enormous variety of exceptions, going all the way back to the Terminal Railroad case, where this corporation that owned the railroad terminal and bridge across the Mississippi River at the turn of the 20th century was actually run by a set of shareholders, each of whom owned railroads, loading docks and terminals and so on, all the way through the American Needle case, of just 10 years ago, American Needle versus NFL, in which NFL Properties, an LLC owned by the NFL football teams, used a single organization as a vehicle for licensing out the separate trademarks and other intellectual property held by the NFL, the individual NFL teams. If we would restructure, say, Amazon as a firm in which relevant decision-making, and this doesn't even require a transfer of shares. It only requires the appointment of a board with relevant decision-making power that would transfer decision-making power to a group of active participants on Amazon. Now, who would those be? Those would be merchandisers who advertise on it for their products. It might be other types of advertisers. It could be consumers, various types of suppliers. But the effect would be that a product decision that Amazon made would be treated as collaborative rather than as unilateral. And then the more aggressive features of Section 1 of the Sherman Act could be brought into bear. Now, I hasten to add one thing, and I know this makes some people uncomfortable. Amazon would not necessarily become smaller under such an approach. And indeed, to the extent that we eliminate internal imperfections in competition by such a mechanism, it could actually become greater if it become larger as its prices move more towards marginal cost. But I think that's a more creative remedy that the courts have yet to explore.
Yeah, I totally agree, and very insightful. It's much more accurate in terms of saying big is bad or big is not bad, and then what's the goal is to curb the size or whatever. This is much more insightful. And one final question for me, which is if there is anything that's missing in a House report or problematic in your view, if you can quickly, and then we can talk about that, and then that would be the final substantive.
Well, yeah, I think there's one remedy for recent acquisitions that should be looked at. It won't work in every case, but that is permit acquisitions of non-exclusive licenses. That is to say, if Facebook really needs WhatsApp to improve the quality of its messaging, well, what does it need? Well, what it needs is WhatsApp's intellectual property, not the building or the ground. What it needs is WhatsApp's intellectual property. A non-exclusive license can give Facebook all it needs to improve the quality of its own product without the power to exclude other folks. And I think that's a remedy. That's an old remedy. The AT&T divestitures required cross-licensing, non-exclusive cross-licensing of millions of patents because all of the various components of the phone company couldn't function unless they had access to AT&T's patents. AT&T at the time was the largest patent owner in the world. And I think non-exclusive licenses are good remedies for facilitating improvement in high-tech markets without facilitating exclusion.
Professor, very, very fascinating. And I think you've illuminated not just remedies that Congress, the FTC, DOJ, and court should be thinking about, but also good governance practices and business practices that companies can adopt on their own, independently of a court order, to avoid some of these monopolization claims. I know Anora and I could talk about this for hours, but we are at the end of our time. But before we let you go, just a few more questions that we'd like to ask each of our guests. Professor, if you could tell us something interesting about yourself that we wouldn't know about you if we just knew you professionally.
Well, the fact is my life's not all that interesting. I do love making soup, and I'm pretty good at it. So come over sometime and you can try some out. Any
recent soups that you've made during the crisis? I feel like everyone's doing something new.
I've been experimenting with vegan lentil soups. They're very healthy, and I recommend them.
Should we share the recipe on the website as well?
No. Proprietary.
Trade secret. And Professor, what advice do you have for students or younger lawyers looking to do what you do?
If they really want to get serious in antitrust, my advice is that if you have the means, and I know not everyone does, try to get some graduate work done in some non-legal discipline. Economics comes to mind as an obvious choice. Engineering is another one. But, antitrust is moving very rapidly in the direction of tech. When I went to law school, it was all about car dealers and distributors of, car products. We've been there and we've done that. All of the next cases that are going to be interesting are going to come up in platform markets with a high digital content and with rapid technological turnover. And a good lawyer understands the markets that she is working in.
And it is a complicated market to understand. So.
Yes, it is.
Great advice.
So for our final segment of Our Curious Amalgam is Our Curious Hat.
And now it's time for the Curious Hat.
So, Professor Hovenkamp, in normal circumstances, we would actually have a physical hat that we would hand you, and you would draw out a number. Obviously, we're doing everything virtually, so if you could pick a number 1 through 25.
Okay. And do I tell you what it is?
Yes.
Oh, okay.
12. Okay. Oh, well, I think we might already know the answer to this, but what is your favorite thing to cook?
Oh, yeah, you already know the answer to that. Sorry.
Okay. How about between tater tots, French fries, or onion rings? Which would you pick and why?
I stay away from all of those things.
You have your vegan lentils.
Yeah.
I stay away from fried foods to the extent I can.
Is there a kind of soup that in your mind that needs the most improvement? Like, the common types of soups that's served out there in restaurants?
Yeah, cream soups, I think we should either do away with or figure out some way to make them healthy so, you don't have to have an ambulance standing by when you eat a bowl of soup.
But they make people happy, I guess.
In the short run.
Well, Professor, thank you again for joining us. And to those of you listening, hope you enjoyed. We'll see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.